So let's say you're charged with a crime. Never thought in your lifetime that you would ever be charged with a crime, but here you are in court charged with a crime. And the prosecutor offers you a plea deal, and you have to decide, should I take this plea deal or should I go to trial? This is one of the top questions that I get as a criminal defense attorney. Should I plead guilty? And so what I've done is I've developed a list of 7 things, crucial things that I want you to consider if you're ever deciding on whether or not you should take a plea offer in a criminal case. Obviously, nobody wants to plead guilty, but ultimately it's really going to come down to whether or not a guilty plea is going to be in your best interest or not. So let me run through this list of the 7 things that you should consider if you're ever thinking about taking a plea offer in a criminal case. So number 1, are they offering a better outcome than what you would get if you were to go to trial? So for instance, let's say you have a total of 3 charges and they're dropping 2 of the charges for a plea in 1 of the charges. Are they dropping charges that ultimately you probably would be convicted of at trial? So understand that going to trial, the outcome that you're stuck with is the outcome that you're stuck with. The judge would only have the ability to sentence you on what you've been convicted of. But if you take a plea deal, the judge can't sentence you on a charge that was dismissed. The judge would only have to sentence you on the charges that you pled guilty to. So the first thing that you should consider is whether or not the charges that they're dropping are in your best interest, and whether you would even be convicted of those charges if you were to go to trial as well. So if they're dropping charges, if they're offering less time than what you would get if you were to, as opposed to you going to trial, those are things that you want to consider. So that's number 1. So number 2, would you get a worse sentence if you were to go to trial? This is a major thing that you want to consider, because ultimately what we typically see in criminal court is if you go to trial, the judge is going to potentially consider giving you a harsher penalty than you taking responsibility and pleading guilty to the charges or to the charge that you're offered. And so you want to consider, what would your possible sentence be if you were to go to trial versus what your possible sentence would be if you were to plead guilty. So some of the things that the judge is considering is, are you wasting the court's time? Are you taking responsibility for your actions? Are you wasting court resources by having a jury convene potentially for multiple days to hear your trial, only for you to be convicted of the same charges that you could have pled guilty to? So just understand the dynamics of the jurisdiction that you're in and how sentencing works in your particular court or jurisdiction. Number 3, this is a good one. Would you be able to get evidence suppressed if you were to go to trial? I think oftentimes, people who are considering taking a guilty plea, they may say something to the effect of, well, the police illegally stopped me, or the police illegally searched my car. And while that may be the case, you can only argue that if you go to trial. You may have to ultimately decide, should I take a guilty plea and just kind of cut my losses here, even though I know the police illegally arrested me, detained me, searched my belongings or otherwise? Or should I take the chances of going to trial and arguing to the judge that the evidence was illegally obtained and therefore the evidence should not be used at a trial in my case? But the only issue is you would have to reject a plea offer from a prosecutor in order to now go to trial to make that argument. But understand that once you decide to plead guilty, you can't come back and say, hey, the police violated my rights. They violated my constitutional rights. They illegally searched me, or they illegally detained me. You can't come back and make those arguments once you take a guilty plea. So you have to be firm on whether or not you want to waive or not pursue those arguments to potentially suppress evidence or get evidence thrown out if you were to take a guilty plea. But if you think that you're in front of a judge who would potentially throw out evidence if you were to go to trial and argue that the police or the government illegally violated your rights, then that may be something that you want to consider with respect to potentially going forward to trial instead of taking a plea offer from a prosecutor. Number 4, how would a plea offer affect other areas of your life? This is a really important one that I feel like a lot of people don't realize that they should actually consider, because there's nothing worse than taking a plea deal only to never be able to function in life, right? So for example, let's say you take a plea offer, but now it permanently puts you out of a job. Is that a plea offer that's really worth taking? Ultimately, if you're taking the plea offer, you kind of still want to be able to get a job, pursue opportunities, pursue education or otherwise. But ultimately, if you take a plea offer and you can't do anything else with your life, is it really worth it? Another thing that you may want to consider is, let's say, immigration consequences. That's another major area of your life that could be affected if you take a guilty plea. Usually, especially in the domestic violence space, if you are not a U.S. citizen, let's say you are a green card holder and you take a guilty plea to a domestic violence offense, or you are found guilty of violating a protection order or a restraining order from a family member or former partner, now you're in a situation where you could potentially be deported. If you go out of the country and you try to come back into the country, you can now be excluded from admission back into the United States, and you can have so many other consequences that affect you. And so ultimately, you want to decide, is taking a guilty plea going to affect any other area of your life? If you are a person that has a special type of license, let's say you work with children or you work with the elderly, will a guilty plea affect your ability to renew your professional license in the future? All of these things you want to consider when you are deciding if you should take a guilty plea or not. Number 5, should you testify? This is a big one. A lot of the time people want to be heard. They're saying, the police never heard my version of events, or, nobody knows what happened because I never spoke up for myself. And so oftentimes some people may want to testify and tell the judge their version of what actually happened, as opposed to their version that maybe the prosecutor is portraying to the court. Now, testifying is a little complicated because there are other things that could come into play at a trial in your case. For example, if you have certain convictions, those convictions can be used to what is called impeach you. Now, impeachment means that the judge is able to take notice that you are not a credible witness because of certain facts or certain information that is now available to the court. So for example, one that I see common in a lot of jurisdictions is if you have been convicted or you pled guilty to a crime of dishonesty, let's say fraud or theft or something that shows that there's a crime of dishonesty, in some jurisdictions, that is something that a prosecutor can now provide to the judge or to a jury to let them know that you are a person who has been found guilty of being dishonest, and therefore they should consider that criminal conviction and whether or not they should believe your testimony or not. So testifying can be a little bit complicated. Another issue that you may want to consider if you testify is what would come up on cross-examination. If your attorney is calling you to testify, it's easy breezy, right? But once the prosecutor cross-examines you, they're going to say a lot of nasty things about you, and that's kind of their job. That's what their goal is. They may want to get you a little bit riled up for purposes of cross-examination to show the jury that you're an angry person, or to show the judge that you can't even hold your temper in a courtroom. And so cross-examination, it can get a little serious now. And so you would want to be sure that you are someone who can come across as believable when you testify, but then also that no other information or negative information about you can hinder you or would hinder you if you were to testify in a trial in your case. Number 6 is, what additional evidence would come out at trial? This can range significantly. There could be DNA evidence, there could be fingerprint evidence, there could be other forensic evidence, there could be video footage, there could be audio recordings, there could be phone calls and other documents that are permitted to be presented at trial. So what evidence would be able to come into trial, and would that evidence help you or would it hurt you? Oftentimes, your attorney may say, hey, look, we want to be able to provide this evidence to the court and to the jury at trial, but then that piece of evidence gets objected to, and that was your main piece of evidence to present at trial. Now what do you do? Or, let's say a prosecutor may want to provide evidence against you, and your attorney says, oh, we're going to object to that. That's not relevant for purposes of trial, but then the judge lets it in. Now what do you do? You're stuck with whatever evidence is admitted at trial. So you really want to decide what evidence is going to be admitted at trial, and would this help you, or would it actually completely derail your chances of a not guilty finding at trial? And number 7, the 7th thing that you should consider if you're deciding taking a guilty plea is what witnesses would end up testifying at trial. This is major. Now, understand that in criminal cases, usually the fact that there will be less defense witnesses than there are prosecutors' witnesses. So that's just a given fact. So sometimes it's just one witness, and it's you, the person that's charged, the defendant, that testified. It could be the defendant and maybe 1 or 2 other witnesses, or depending on how serious the trial is, there could be DNA experts, forensic experts, fingerprint experts, so forth and so on. But ultimately, what witnesses would be able to testify at trial? One of the major reasons why trials can kind of take a turn is if a witness is not available. So for instance, let's say for whatever reason, one of your main witnesses now moves to another state or jurisdiction. Are they really going to take the time to fly out or to drive back to your courtroom or to your state for the trial in your case? Is it worth it? Let's say they want to be compensated for the time that they're taking away from work or otherwise. Is that something that can be done? Now, ultimately, a subpoena is a subpoena, right? If a person doesn't show up and they've been subpoenaed to testify, then, there could be other steps that are taken, such as asking the judge to issue a warrant for that person to come to court and testify because they never showed up after they were subpoenaed. But at the end of the day, Do you want a hostile witness testifying on your behalf? Do you want somebody who has now been, they've dragged this person into court because this person refuses to show up and they're supposed to be testifying on your behalf? Is that the witness that you really want? Because that witness may show up in handcuffs and shackles because they didn't want to be there and because they were only there because it was a warrant that was issued for them for failure to appear. So understand that witnesses can get complicated. You want to make sure that they're readily available. Sometimes people change their numbers, they change their addresses, and then you can't find them anymore. It takes usually several months at least for a trial to move forward. If you're detained, maybe obviously for speedy trial purposes, your trial may be sooner. But do you have witnesses that are going to be comfortable testifying? Sometimes people, they don't want to be a rat. They want to feel like they're telling on anyone. And so sometimes people are private and they say, no, I support you, but I don't want to show up in court. So having really credible witnesses, that's going to be important. Witnesses that are willing to show up, that's also going to be important. And you also want to know the criminal record of your witnesses, because just like any other witness, if that witness has a crime of dishonesty on their record that they pled guilty to or that they were found guilty of, then that witness testifying may not be in your best interest if now they can be impeached, which means that there's a finding that they're not as credible or they don't have to be believed because they have a crime of dishonesty on their record. So if you weigh these 7 factors that I have provided to you, you would be much more prepared in deciding and making a really thoughtful decision on whether you should plead guilty or if it would be better for you to go to trial. So I hope that's helpful to you. If you have any questions, feel free to comment them below and I'm always happy to answer them for you. And if you like this content, go ahead and like and follow for more.